Hi everyone. This video will examine the following. 1. The rights of a school to ask whether your child has been vaccinated against COVID-19. 2. The rights of a school to require your child's temperature to be checked each day as a condition of admission. 3. The age at which a child can provide consent to medical treatment without parental knowledge or consent. 4. Whether it would be possible to make mandatory in law the COVID-19 vaccine for children in schools. 5. Whether one parent or two parent consent is required for medical treatment for your child, including the COVID-19 vaccine. 6. What is informed consent? And 7. Can your child's school require that they be tested for COVID-19 using a PCR test if they are a close contact? So the first topic, the rights of a school to ask whether your child has been vaccinated against COVID-19. Most of you have probably seen the newspaper articles that were published yesterday, so the 14th of August 2021, advising that vaccinated pupils will not have to stay home if they are a close contact of a COVID case in school, but unvaccinated children will have to take time out of class. So we now know that there is a clear intention to treat vaccinated and unvaccinated children differently. The most likely reason being to ensure that everyone in the class knows which children have received the vaccine in order to ensure that unvaccinated children are treated differently, thereby ensuring that the pressure for vaccination comes not only from the government, the media, NEFIT and the school, but also from the children themselves. As matters stand today, there is no lawful basis to ask whether your child has been vaccinated against COVID-19 at school. The most important piece of guidance to support this position was published by the Office of the Data Commissioner on the 22nd of June 2021. This document specifically concerns the processing of COVID-19 vaccine data in the context of employment. However, the same advice could be applied in many other settings, including, in my view, all educational institutions, so primary school, secondary school, third level and any type of training course. This same advice would also apply to anyone working in any of these institutions, such as teachers. The guidance published by the Data Commissioner states, in the absence of clear advice from public health authorities, that it is necessary for all employers and managers of workplaces to establish vaccination status of employees and workers. The processing of vaccine data is likely to represent unnecessary and excessive data collection for which no clear legal basis exists. This is particularly the case where there is no public health advice pertaining to what the purpose of such data collection would be. I've included a link to the Data Commissioner's guidance in the description box of this video so you can review it for yourself. What this means is that unless the Department of Health or another official public health authority advises that schools must collect the vaccination status of pupils for a particular purpose, then there is no lawful basis to do so. In light of same, I have included a template letter that may be issued to your child's school in circumstances where they are asked whether your child has been vaccinated. This letter sets out in detail why asking for this information is considered unlawful. I would strongly suggest that you read this letter to understand the law in this area, as understanding the data protection restrictions around health data will prove a useful tool going forward. That said, I am aware that the Department of Education intend to issue updated guidance around return to school inside the next 2 weeks, so if the advice around entitlement to ask whether your child has been vaccinated changes, I will do a brief video updating the position. 2. The rights of a school to require your child's temperature to be checked each day as a condition of admission. As you will be aware, temperature testing became a common feature in schools during 2020. I did a video on this in September 2020 and this advice has not changed. The advice at the time was that there is no lawful basis to require your child to submit to temperature testing in schools unless you consent. Both vaccination status data and temperature checking data are special categories of data under the General Data Protection Regulations. This means that the school or employer, if you are a teacher in the school, cannot simply ask for this information without having a lawful basis to do so. With regard to temperature checking, it is worth noting that the Data Protection Commission issued guidance last year to the effect that temperature checking in the workplace would only be considered necessary and proportionate in circumstances where public health authorities or other relevant authorities are recommending such measures. With regard to temperature checking, it is worth noting that the Data Protection Commission issued guidance last year to the effect that temperature checking in the workplace would only be considered necessary and proportionate in circumstances where public health authorities or other relevant authorities are recommending such measures. We can use the same logic with regard to considerations around temperature checking in schools. In this regard, it is worth noting that the COVID-19 response plan for the safe and sustainable reopening of primary and special schools and post-primary schools, published in September 2020 and April 2021, makes no reference to a requirement to check a child's temperature. Therefore, unless your child's school has been identified as particularly high risk, the school in question must justify why any consequent processing of personal data is necessary. That said, in order to maintain an element of civility with your child's school, you could suggest a workaround, which might include advising the school through a declaration that you do not consent to your child's temperature being taken, but that in the interests of public health, you shall commit to taking your child's temperature each morning before they leave for school, and in circumstances where your child's temperature is above average, you will not send them to school. If you wish to utilise this option, I've prepared a non-consent declaration form which can be found at the Google link in the description box of this video. 3. The age at which children can provide consent to medical treatment without parental knowledge or consent. When we talk about the age of consent for minors, the relevant piece of legislation is Section 23 of the Non-Fatal Offences Against the Person Act 1997, which provides that a person over the age of 16 years can give consent to surgical, medical or dental treatment without needing to obtain consent from their parents or legal guardian. So the first thing to note is that if your child is over the age of 16 years, they may be approached in the school or by their GP to see if they want the COVID-19 vaccine. So you should ensure that your child is educated on the risks versus the benefits of this vaccine. Ensure that they are aware that they may be approached while in school, and also ensure that they are aware that the vaccine is not mandatory regardless of what they are told. The law with regard to children under the age of 16 years is a little less straightforward in this country. I say this due to guidance issued by the HSE in their National Consent Policy version 1.3, which at part 2 deals with children and minors and confirms that the age of consent with respect to surgical, medical or dental treatments is 16 years of age. However, this policy goes on to state that a mature minor, so this is a child under the age of 16 years with no lower age limit, who is considered by a healthcare provider to have sufficient understanding and intelligence to enable that child to understand what is being proposed, can give consent to their own medical treatment without parental consent or knowledge. The HSE consent policy goes on to state that the concept of mature minor is accepted in other jurisdictions such as Northern Ireland, Scotland, New Zealand, Australia and Canada. So with regard to children under the age of 16, again I would advise that you ensure that your child is educated on the risks versus the benefits of this vaccine. Ensure that they are aware that they may be approached while in school, and ensure that they are aware that the vaccine is not mandatory. With regard to children under the age of 16, I would also advise that you send both your child's school and their GP a non-consent form advising that you do not consent to the COVID vaccine being given to your child without your prior written consent, and also confirming that your child does not have the maturity, the intelligence or the understanding to give informed consent without parental involvement. They should be advised that in this regard, should a decision be made by the school or healthcare provider that your child is considered a mature minor, that you will hold them personally liable for loss, damage, injury and interference with your constitutional rights to safeguard the welfare of your child. For completeness, I've included a template parental non-consent form in the description box of this video. Just on the issue of mature minor, several people have asked if I could discuss the concept of Gillick competence. Just to be clear, mature minor and Gillick competence are the same thing. A lot of people have taken comfort from the Bell versus Tavistock court case. This is an English court case and answers the question of whether puberty blockers could be prescribed to under 18s with gender dysphoria. The judgment in this case was handed down on the 1st of December 2020 and held that it was highly unlikely that a child aged 13 years or less would be competent to give consent to the administration of puberty blockers, and that it was doubtful that a 14 or 15-year-old could understand the long-term risks and consequences of this form of treatment. That said, this judgment was appealed in January 2021, with the appeal hearing taking place on the 23rd and 24th of June 2021, so we are awaiting this judgment. There are many who believe that the 2020 judgment will be overturned to a certain degree, so we need to wait to see what this appeal judgment says before advising further. That said, even if this appeal judgment overturns the 2020 judgment, it is questionable as to whether a court would consider the COVID-19 vaccine to be as serious a medical procedure as puberty blockers. Personally, I fear they would not. 4. Whether it would be possible to make mandatory in law the COVID-19 vaccine for children in schools. In my view, the COVID-19 will not be made mandatory in law for primary, secondary or third level education. I think it is far more likely that educational institutions, in concert with the government, will employ coercive measures to encourage pupils to take the vaccine, such as the coercive measures we hear are planned for secondary schools around allowing vaccinated students who are close contacts to evade COVID-19 testing or isolation. With regard to mandating the COVID-19 vaccine in schools, the following constitutional protections exist. A. Article 42.1, which states, "The state acknowledges that the primary and natural educator of the child is the family, and guarantees to respect the inalienable right and duty of parents to provide, according to their means, for the religious and moral, intellectual, physical and social education of their children." B. Article 42.4, which states, "The state shall provide for free primary education." This Article 42.4 is particularly important as we know that in 2019 Simon Harris sought advice from the Attorney General around the legality of mandating vaccinations in schools, and he was advised at the time that it would be legally challenging given a number of competing protections under the Constitution. In this regard, there appears to have been specific reference to the right to free primary education as being a barrier. C. Article 40.3.1, which concerns the unenumerated right to bodily integrity, which was first recognised in 1965. And D. Article 41.1, which states, "The state recognises the family as the natural, primary and fundamental unit group of society and as a moral institution possessing inalienable and imprescriptible rights antecedent and superior to all positive law." To conclude, it is my view that the COVID-19 vaccine will not be made mandatory in schools. That said, other avenues in addition to coercive measures may be considered, such as mandating the COVID vaccine in creches. There is no suggestion that this is being considered, however, this is something that they may look at into the future. 5. Whether one parent or two parent consent is required for medical treatment for your child, which includes the COVID-19 vaccine. Under current Irish law, the mother has automatic parental responsibility for the child. However, the father is also given parental responsibility if A. he is married to the mother at the time of the child's birth, B. they marry after the child's birth, or C. if they both adopt the child together. If a child is born outside of marriage, the mother is given automatic responsibility for all decisions relating to the child. However, the father has automatic guardianship if he has lived with the mother for 12 consecutive months, including 3 months after the child is born, but this 12-month period must have commenced after January 2016. The father of the child can also apply to the court to become the child's legal guardian. With respect to legally separated parents, unless a court order states otherwise, both parents have responsibility for medical treatment for the child. So, in certain circumstances, such as where the parents never married, lived together, and where the father has not sought guardianship through the courts, the mother has sole responsibility for making medical decisions for the child, including whether the child should be vaccinated. In circumstances where the parents were married before or after the child's birth, lived together or are legally separated, both parents have responsibility for the medical decisions for the child. That said, there is currently discussion in health and social care settings as to whether one or both parents or legal guardians must consent to medical treatment for a child, with the generally accepted principle in other jurisdictions being that the healthcare provider will not be held liable for battery in criminal law if they administer medical treatment, including vaccinations, where they have secured the consent of one parent. This means that one parent consent will likely be accepted by schools, GPs and vaccination centres. In order to try and preempt any difficulty in this area, I've included a section in the COVID-19 non-consent to vaccination letter, which confirms that you do not consider one parent consent to be sufficient, and that should the vaccine be administered using one parent consent, that you will hold the principal of the school, the board of management and the healthcare provider personally liable for any loss, damage or injury suffered by your child and for interference with your constitutional right to safeguard the welfare of your child. 6. What is informed consent? According to the HSE guidance titled Consent for Vaccination for COVID-19 Guiding Principles dated the 5th of March 2021, consent is the giving of permission or agreement for an intervention, such as a vaccination, following a process of communication about the proposed intervention. And informed consent is stated to involve a process of communication between a healthcare worker and a person that enables that person to have a clear understanding of the nature of the intervention and the likely risks and benefits of receiving it, thus enabling the person to make an informed choice about whether or not to proceed. This document goes on to state that for informed consent to be valid, the person must 1. Have received sufficient information in a comprehensible manner about the nature, potential risks and benefits of the proposed intervention, of any alternative interventions and of not receiving the intervention. 2. Not be acting under duress. And 3. Have the decision-making capacity to make the decision, even if requiring support to do so. Lastly, 7. Can your child's school require that they be tested for COVID-19 using a PCR test if they are a close contact? The only current reference to mandatory treatment is set out in Section 11 of the Health Preservation and Protection and Other Emergency Measures in the Public Interest Act 2020, which deals with detention and isolation of persons in certain circumstances. Section 11 provides if a medical officer believes in good faith that A. A person is a potential source of infection, and B. The person is a potential risk to public health, and C. His or her detention and isolation is appropriate in order to prevent, limit, minimise or slow the spread of COVID-19 and minimise the risk to human life or public health. And D. This is the most important part. Such person cannot be effectively isolated, refuses to remain or appears unlikely to remain in his or her home or other accommodation arranged by the HSE. Then the officer may in writing order the detention and isolation of such person in a hospital or other place until such time as the medical officer certifies that the person's detention is no longer required. So it is only under circumstances where a person has been detained in this way that there is a possibility of them being forcibly subjected to medical treatment, including testing. What this means is, in my view, if you are willing to detain your child at home for 14 days or as recommended, upon becoming aware that your child is a close contact, then there is no lawful basis to require your child to be tested for COVID-19 using a PCR or any other kind of test. To conclude, in the description box of this video, you will find a link to the following documents. A. Data Protection Office guidance on the processing of COVID-19 vaccination data. B. Data Protection Office guidance on the processing of temperature checking data. C. A template letter that may be issued to your child's school in circumstances where you are asked whether your child has been vaccinated against COVID-19. D. Declaration advising that you do not consent to your child's temperature being taken, but that in the interests of public health, you will commit to taking your child's temperature each morning before they leave for school, and that you will further commit that in circumstances where your child's temperature is above average, you will not send them to school. E. COVID-19 vaccine non-consent form, advising that you do not consent to the COVID vaccine being given to your child without your prior written consent, and confirming that your child does not have the maturity, understanding or intelligence to give informed consent without parental involvement, and also that you do not consider one parent consent to be sufficient. If any of the recommended measures in this video change arising from new guidance issued by the Department of Education over the next several weeks, I will update this video and issue new template documents. Thanks for listening.